Namaskar, I am Advocate Saurabh Kunal. Welcome to my channel. Here we discuss issues of legal and financial education. So today we are going to discuss about anticipatory bail. So in this video we will be discussing what is anticipatory bail, how one can avail this anticipatory bail, what are the provisions of law for getting anticipatory bail, is there any precondition? So we will also be discussing about the preconditions for getting bail. And we will also be discussing the guidelines and the landmark judgments of the Honorable Supreme Court in anticipatory bail. Apart from that, we will also be discussing how to draft a proper anticipatory bail petition. So let's start the video, but before that I will request everyone to please subscribe my channel if you have not subscribed it yet, and please inform me with your views and opinion in the comment box, and please like if you like the video. So let's start. What is anticipatory bail? So friends, let me tell you that anticipatory bail is not defined anywhere in the Code of Criminal Procedure, but the provision of pre-arrest bail is given under section 438 of the Code of Criminal Procedure. So under that provision we can apply for the anticipatory bail. So there are two conditions before filing the anticipatory bail. First, a FIR must be registered in some cognizable and non-bailable offences, and second, if there is a grave concern or if there is a grave apprehension to a person that the police may arrest him for any false charges or on any concocted story. So these are the two conditions, precondition on that we can file an anticipatory bail. Now let's start with the guidelines and the judgments. So it is very important to know what are the guidelines and the judgments of the Honorable Supreme Court. So in the Bipin Bhai versus State of Gujarat, the Honorable Supreme Court has said not granting anticipatory bail is a violation of the Article 21 of the Constitution of India. So anticipatory bail is a kind of constraint on the personal liberty. So if anyone has apprehension of arrest, so the court must consider such application, and this is a genuine ground, and this is a genuine ground for getting anticipatory bail. The next is what is the time limit, because this is also many people ask question after getting anticipatory bail, how long it will be valid. So there is no time limit. I must tell you, in the Susila Agarwal versus State of Delhi, the Honorable Supreme Court has said it in its judgment that there is no time limit for the anticipatory bail. It varies case to case. So obviously there is no time limit given to an anticipatory bail that it will remain valid till this date. So there is no such provision in anticipatory bail. The third is because in various domestic violence cases or in the 498 cases, it is the finding of the court, Honorable Supreme Court, that out of 100 cases, in 85% of the cases the prosecution story is not established in the court of law. So it means that 85% cases are frivolous cases. So that is why in year 2014 the Supreme Court has issued some guidelines that in case if a case is registered, because generally what happens that this 498A, which is meant to be a shield to the woman in the matrimonial house, it is sometimes it is used misused, I must say it is misused as a weapon to harass the in-laws by a woman. So in this condition, the Supreme Court has issued guidelines in Arnesh Kumar versus State of Bihar that the police officer must not arrest a person in 498A cases, and it has given clear-cut direction that in any offences where the imprisonment is less than 7 years, then in those cases the police must not arrest them immediately, but they should issue a notice, a request notice under section 41A, and then request them to come and cooperate in the investigation, and later on if they find that they have sufficient ground, they can arrest. But in the meanwhile the accused or the person has the sufficient time to exercise his other legal and administrative remedies. For example, he can approach the court for anticipatory bail, or for questioning the FIR, he can approach the Honorable Supreme Court. So these are the guidelines given by the Honorable Supreme Court for availing the anticipatory bail. So this is the bottom line. Now what would be the jurisdiction? So to decide the jurisdiction, a person can file his anticipatory bail in the session court, in the district court, where the honorable district judge will decide whether he should be granted anticipatory bail or not, or he can also file it to the high court directly. Means without going to the district court, he can file to the high court. But in my personal opinion, it is always advisable to go through a proper channel. First you approach the district court, then the high court, and finally to the Supreme Court. This is the appropriate way to approach the court. So this is the way to find the jurisdiction of the in the anticipatory bail. Now how to draft, that is the very important question, how to draft an anticipatory bail. So before going to the prescribed format, I would must say that there are two things that one must know before drafting any anticipatory bail. First is he should be well versed with the law. For example, in the FIR various sections are mentioned. So before filing any anticipatory bail, it is very important to know the sections well. One should be well versed with the sections. What are the ingredients of the section? So he should be well versed with the section. And second thing is he should also be knowing about the settled principles of law. So because our judiciary is working since very long, and almost in every offenses the courts work on the settled principle. So one must know what are the settled principles of law in particular offenses, because it will be easier to find to make the ground. So these are the two important things before drafting the bail petition. Now coming to the next part, how to draft it. So first you have to write the name of the court, whether it's a district court or the high court. You have to give the heading. Then you have to write in the matter of state versus the petitioner. Here I want to mention that the state is one party in any criminal cases would be the state, and the second party would be the any accused. So this is, so at the place of the petitioner you have to name the who is the petitioner. Then you have to write an application under section 438 of the CRPC for bail, anticipatory bail. Then in the matter of, then in the first paragraph you have to write the age and address of the petitioner, that the petitioner above said aged about and then he is the resident of such and such place. So this is the information that you have to give in the first paragraph. In the second paragraph you have to give that what is the where the FIR has been registered, what is the date, in which police station it has been registered, and under what section it has been registered. This is the information that you have to give in the second paragraph. In the third paragraph you have to mention whether the petitioner is a law-abiding citizen, or is he does he have any criminal antecedent. Criminal antecedent means the past history, past criminal background, whether he is wanted or he is on bail in other criminal cases. So these are the information that you have to give in the third paragraph. In the fourth paragraph you have to give the prosecution story. What you have to narrate the entire story of the FIR in the fourth story, and in the fifth paragraph you have to give your own facts and grounds, your facts, whether this FIR is a concocted story or what is the actual fact, what is the reality, and you have to give the ground and all the case laws you have to give. Then in the next paragraph you have to mention whether any similar bail petition has been filed in district court or the high court or the Supreme Court or not. This is also very important aspect. You have to also mention that whether it's a first anticipatory bail application or the second anticipatory bail application. Particularly in case of Delhi, there you have to mention whether it's a first anticipatory bail application or the second anticipatory bail application, because in case first anticipatory bail application is dismissed, then you have to attach the court order of the first bail application. And likewise you have to also give, for example, that whether after that you have to give in the next paragraph you have to give details whether the petitioner will fulfill all the conditions of the bail, and in the next paragraph you have to also describe that he has the sureties. For sureties means the guarantor who will take guarantee that in case the accused escapes the investigation or runs away from the investigation. So these are the things that you have to mention in the anticipatory bail application. So if you like my video, please like the video and let me know with your views and opinion in the comment box. So, and thank you for watching my channel. Thank you.